Great. Good afternoon, everyone. It is 12:30, so we will go ahead and get started. We appreciate you spending your lunch hour with us for a topic that may not be the most riveting in the moment, but is a very important topic that we find is implicated in a lot of what we do. So we're going to do our best to make this as interactive as possible and as informative as possible for your day-to-day. A couple of housekeeping items that you're familiar with if you've attended these before. You can submit questions in the chat box during this session, and we will do our best to respond to those either as the presentation goes on or at the end. We will provide a SHRM code at the end of the presentation. And as always, we will send out our slides and the recording from this presentation tomorrow. And with that, we will go ahead and get started. So I'm Jessi Thaller-Moran. I'm an attorney in our Raleigh office. I practice labor and employment work and some business litigation, and I will let my colleague Elizabeth Troutman introduce herself.
Hi, I'm Elizabeth Troutman. I'm an attorney in our Greensboro office. I practice labor and employment law as well as education law. And I am so excited to be here today, actually, because this topic is really near and dear to our hearts as attorneys. Sort of keeping the privilege and keeping confidences is a big part of our duty to our clients, and we all take it really seriously. It's just so important that people have somebody that they can go to get legal advice from and share information with without sort of fear of judgment or reprisal. And so we all take it really seriously, and we're excited to be here to share with you more about what the privilege is and how it works.
And I will echo what Elizabeth just mentioned and say that what we see so often as Labor and Employment Counsel is that we are providing you with advice that needs to get to somebody in your organization to address an issue, right? A personnel issue or someone's request for leave or any myriad of things that can arise when you're managing people. And what we find on the back end of things is that there are really important precautions that need to be taken when you're sharing information or not with an attorney and with your colleagues. And our goal today is to give you a roadmap for how to do everything you can to protect that privilege in the event it moves on to something that is more adversarial. As always, here's our disclaimer that this is for general information purposes. It's not for legal advice. And please consult an attorney for legal advice if you have questions about your specific situation. With that, we're going to ask you to pause for a moment and imagine a scenario that may or may not feel a little bit familiar to your day-to-day, okay? So imagine it's an ordinary Tuesday. Everything's great. Everyone's happy. You've had plenty of coffee. You're being very productive. And suddenly,
dun, dun, dun.
There's a literal pants on fire emergency. You have an employee who has announced to the company they will be setting their own pants on fire in protest if you don't immediately give them a raise. So you panic and you call your favorite listening ear, that superhero who has all the great information and is so good at listening to your problems. You call your lawyer. Oh, nice superhero.
Sorry, Jessi.
We didn't rehearse that one. No, in all seriousness. So the receptionist comes running into your office to take notes so that you can focus on the phone call. You have the call on speakerphone so that you can pace because this is a very high stress situation and your door is open to your office. There are people sitting outside of the office working in their cubicles and people love drama. They are listening. They can hear everything on the phone call. You're on the phone with this attorney trying to figure out how you got to this point that they're threatening to set themselves on fire. And you mentioned, they recently requested some FMLA. And in hindsight, you're not sure that you processed it just the right way. And also, employee A is kind of a squeaky wheel in the workplace, and they keep wanting to talk about wages with their coworkers. You've had to reprimand them on several occasions to stop talking about these personnel matters, which you view as private. So you're on the phone with legal counsel, and legal counsel tells you, you know what, there actually are liability concerns for the company from the facts you described. You really didn't process their FMLA leave request appropriately, and it probably should have been granted instead of denied. And the prior reprimands for the employee discussing wages, You might have actually run afoul of the NLRA when you did that. So the counsel, because what's the point of having counsel in a moment like this, if not to speak frankly, tells you, you guys need to be prepared to pay up. You need to be prepared to pay a settlement, or you're going to have to litigate this. Keep in mind, everybody in the office can hear this. And then the squeaky wheel employee goes ahead and files a lawsuit. They sue for discrimination and for unlawful retaliation. Employee's attorney sends discovery requests for those special confidential call notes from that very important call and takes the deposition of every employee in earshot of that phone call. This is like worst nightmare situation, right? You've had this very important, very private conversation, and now you're being asked to turn over all this information in a court that's going to decide if you're liable. So what happens now? Okay, that was our attempt at a dramatic intro. Now let's back up a little bit and talk about the privilege itself and why it exists, right? It's for moments like that when you sense that there could be legal trouble and you want to be able to have that frank conversation with your attorney about the pitfalls, where you might be headed, and you want to be able to be very frank in that conversation. So the privilege is the client's right to refuse to disclose and to prevent any other person from disclosing confidential communications between the client and the attorney. There are a couple of very important points to this definition. The right belongs to the client. We'll talk in a moment about who the client is when you're talking about a company made up of a lot of people. It can only be waived by the client to prevent confidential communications. We'll talk about that in a moment too, from being shared. So what is a communication here? It's not facts. It's not the fact that the employee previously requested FMLA leave, but it's the communication. It can be an email, a memo, a phone call, or a conversation, or it could even be something nonverbal, right? If you're meeting with your attorney over Zoom and you're kind of shrugging in an uncomfortable way, that might be communication that's protected as well. Facts that pre-existed that conversation are not protected, but the way you shared them is. But then you pair that with an attorney's confidentiality obligations. We as attorneys have an obligation to not reveal information that we acquired during the professional relationship unless the client has given informed consent or that disclosure is impliedly authorized in order to carry out the representation, or there's a list of specific limited exceptions, like a concern that physical harm might occur if you don't disclose something. So we talked about the privilege, which applies to the communication. We as attorneys have an obligation to maintain in confidence what we learned, including facts, so long as that was disclosed to us in confidence. So the pivotal question there becomes whether it was disclosed in confidence by the client to the attorney. And as Elizabeth mentioned, there are good public policy reasons for these protections, right? Trust is the hallmark of the relationship between the client and the lawyer. We, the attorney, want you, the client, to seek legal advice, to communicate fully and frankly with us, even if it's embarrassing or legally damaging. If you work with our firm, you know, we very often tell you that we would rather know all the facts and help you figure out how to work out a solution than find out after the fact that you've told us like half of what's going on and you're embarrassed by the other half. We're here to help, and we can't always help unless we know everything. That's why the privilege exists. And it enables us in turn to advise and represent you as effectively as we can. So for a privilege to exist, there are 5 really important factors that have to be in place. First, there has to be the relationship between the attorney and the client. That sounds like it's straightforward, and sometimes it is, sometimes it's a bit murkier. We'll talk about that. The communication has to have been made in confidence. The third factor is that the communication has to relate to a matter about which the attorney is being professionally consulted in their capacity as a lawyer. The communication has to be made in the course of either giving or seeking legal advice for a proper purpose. Proper purpose just being a caveat that's like, you know, you can't come to us and be like, I want to commit murder. How should I do that? And get away with it. That's not covered. And most importantly, the client cannot have waived the privilege either explicitly or through their conduct. And where this becomes important is if you're in an adversarial proceeding or if you're in litigation before an administrative board, something like that. Something that is not privileged, you can be compelled to hand over to the other side or to the court, to the government agency doing the investigation. If it's privileged, there's a cloak of protection around it that spares you from having to hand that over. But the burden is on the party asserting the privilege to protect the information from being disclosed, which means that there's not a presumption that just because you were talking to me and Elizabeth, the privilege applies. We have to show that the facts and circumstances around that communication show that the privilege is warranted for that particular communication. So let's talk about this first factor, relationship of attorney and client. With a company, as I mentioned before, there's a question about who is the client. And the answer from a highbrow legal perspective is that it's the company as it acts through its agents. So that could be its policymakers, its high-ranking officials. It can also be lower-ranking employees if they are dependent on the relevant legal advice to successfully perform their jobs. That's if they're receiving advice. So that in the employment context might look like you are obtaining advice on how to process someone's request for medical leave. Your leave administrator, even if they're not a top-ranking official, if they need the advice from our firm to effectively process that request for leave, that's more likely to count as advice being provided to the client. And then all employees are covered under the definition of client for the company if they are supplying facts to our firm. And that might come up in the context of something like an investigation. If you've ever had us or another law firm come in to do an internal workplace investigation, we have to be able to talk frankly with the members of your organization to figure out what happened. And if they are telling us things for us to consider in our legal analysis, it's more likely to be covered by that privilege as long as the other factors apply. Now, the client is not employees or representatives in their individual capacity. So we represent the company. We work with the HR director. The HR director is not our client. It's the company, and the HR director is its agent. And then there's a question of whether there's an attorney-client relationship at all. If you work with our firm, you've got an engagement letter in place that says we are an attorney, you are our client. But there are courts that dive into the subjective and objective factors as to who believes if there's a client relationship. And for that reason, you'll hear us a lot of times speaking with employees, specifying that we represent the company, we don't represent them, because we're trying to avoid a situation where there's any misconception there. So that's the first factor. The second requirement is that the communication has to have been made in confidence. Did the client intend for the communication to be made in confidence? Sometimes that's not the case, right? If you're talking to us and we're in the middle of litigation and you want us to tell the other side something, right? Tell their lawyer that we think this, then you're not intending for it to be communicated in confidence. That's not privileged. It gets murkier when you talk about the circumstances of the communication. So the presence of third parties there, someone who doesn't, quote, need to know, going back to that last slide. If you have someone like that receptionist sitting in the call for your convenience to take notes, it's going to be harder to defend that privilege because there's someone who didn't need to be in the conversation. Same with if you work with consultants, like right now we're seeing a lot of activity on the unionizing front. If you have a union consultant who's part of the communication, there are really special protections that need to be taken to make sure that we're not inadvertently bursting that attorney-client bubble by having them sit in a meeting or review an email that we sent. The location and the method of the communication. If we're talking to you in Starbucks, it's going to be harder to argue that it's privileged than if we're talking in a closed conference room. And then the exception I just named a moment ago about sharing for purposes of messaging to the other side. Factors 3 and 4 overlap pretty significantly, and that's that there has to be a professional consultation to give or seek legal advice. This comes up a lot with in-house counsel. I know we have several on this webinar and you all are familiar with this, but the question is going to come whether the lawyer is included in the communication for legal advice or for something else. If the lawyer's copied on an email for accountability purposes, or they're part of a standard company listserv, when I email all company, it happens that the attorney is on that list. It's less likely to be a communication for legal advice. Same with if you're consulting them for business input. And again, in-house counsel, I know you all confront this regularly, where you might be in a strategic meeting that isn't strictly related to the practice of law. And there can be some confusion around whether there is privilege that applies to that conversation. And then the last point I'll make is that if the lawyer is there as a fly on the wall, if they're really just sitting in the room or on the email in hopes that a privilege attaches, but they're not participating in the communication, it's going to be harder to argue that that was communication for legal advice. So again, the primary purpose of the lawyer participating in the call has to be providing legal advice. And with that, we get to, I feel like every factor, I keep saying this is the most important factor. But we're going to dive into waiver, which is what inspired us to put this presentation together. And I'm going to turn it over to Elizabeth to talk through some things we see and flags we want to raise.
Sure. So the first four factors, if you've got those, you've got the privilege, right? You've got a privileged communication. It's been made in confidence. It's been made for the purpose of gaining legal advice. And it is between lawyer and client. So we've got it, but the privilege can be waived, which basically means that all of a sudden this communication is not going to be shielded from disclosure in the future if it gets waived. So typically, right, the client is the one who has the authority to waive. The lawyer does not have any authority to waive the attorney-client privilege. So we as lawyers work very, very hard to protect the privilege, and then clients have the option to waive it, meaning make it more public. What gives us heartburn, though, is when our clients inadvertently waive the privilege. And so we're going to talk a little bit about that to kind of give you all some guideposts around how to avoid waiver. Of course, if you have more specific questions, you should talk to your attorney directly about specific scenarios. So what's waiver? So it's waived if it is disclosed to people who do not need to know the information to do their job effectively or to make informed decisions. So that means you could inadvertently waive the privilege by sharing our advice with other people in the company who really don't need to know the information. So forwarding emails, for example, is something that gives us a lot of concern, because if the person you're forwarding the email to really doesn't need the legal advice in order to do their job effectively or make a decision, well, then that's not going to be a protected communication anymore. So we labeled this slide waving goodbye to privilege. Do you get our pun? So we don't want you to wave goodbye to privilege unless you want to, right? And so think about that whenever you're using attorney advice. One thing I see happen a lot is if we're providing advice with respect to a contract, and we might go through the contract, provide some advice about what the various terms mean. And then all of a sudden that email is forwarded to the party with whom we are negotiating the contract, or with whom you are negotiating the contract. And now all of a sudden that advice that we provided to you is not protected by the privilege. So some common inadvertent waivers of privilege. Like I said, forwarding or repeating attorney communications. I've also heard folks just kind of talking amongst each other, maybe talking to a peer within SHRM and saying, I love working with this attorney. Let me tell you about a situation we had in which Jessi came in and gave me the following advice. Okay, now all of a sudden, whatever Jessi's advice was is not privileged any longer. Another thing that may happen from time to time is a client saying, our attorney told us we had to do this. Now, that sort of refers to whatever the advice was. If you're going to do that, what I'd suggest is that you talk to the attorney first and talk about the pros and cons of waiving that particular communication. Because sometimes it may be appropriate to say, you know, this is legally required, and you might want to refer to the attorney, but you need to understand that when you do that and there's subsequent litigation, then there's a lot of communication that all of a sudden could be made part of that litigation that you did not want to. Another thing that happens frequently is attorneys getting copied on emails where really they're non-clients on the email. So for example, if you have a service provider that you work with and you decide, you know, let's just fold in our attorney to this whole discussion, that's fine to do, but you should understand that there's a risk that that communication is not going to be privileged because there's a non-client involved. So that means we're waiving things that may be below on that email chain, right? You know, with consultants, there are some complications. So if you have a consultant who's sort of working with the legal team, you need to talk to your lawyer about what the privilege looks like there, how to set up an engagement with a consultant and a lawyer together to see what you can do to protect those communications. Okay, so if you go to the next slide. So another thing we see a lot of times are folks who don't take the time to put in place some guardrails around how attorney communications are distributed amongst the company. So if you're in sort of a more senior leadership position, you're probably the one who's in contact with the lawyer. But the further down the organization you go, the less likely the people who are communicating with the lawyer necessarily need to know information. So think about that. It all depends on the type of company that you have or the type of organization that you have and how the structure works. But in terms of giving access to attorney advice, be careful about that because that can create some privilege and waiver issues as well. Another common misconception is around using lawyers for business advice. So we provide legal advice and strategic advice, and you know, legal advice usually isn't in a vacuum. But sometimes folks think that just because they copy a lawyer, all of a sudden the communications are privileged. That is not the case. And if you're asking the lawyer for advice that really isn't legal in nature, then you're going to run a privilege risk there as well. Okay, so that's sort of privilege in a nutshell. Our big concern is around waiver, and if you don't take anything else from this presentation, what we hope you take back is, you know, if I'm going to be telling people about what the lawyer said or forwarding the lawyer's emails, I really need to think through that, or I need to talk to the lawyer about when that's a good idea and when that risk of waiving privilege is something we don't want to take on. So now we're going to talk a little bit about privilege in the context of internal investigations, because these do come up a lot in the labor and employment space. So you all as HR folks are responsible for looking into issues that are raised within the organization. But it may be appropriate sometimes to involve legal counsel in conducting those investigations. So first of all, when you have serious charges that are being brought or serious allegations being made about harassment and discrimination, that automatically triggers the risk of litigation, because folks can go to the EOC, folks can bring a Title VII claim. And so automatically, when you see an employee making allegations of harassment or discrimination, that should raise legal concerns for you. And so because of that, you may want to call the lawyer and talk through, okay, I've got these allegations. How are we going to deal with them? Other situations that it might be helpful are around complaints of process or policy abuse. Now, that's sort of a broad statement, but what we really mean is when you have a situation where it's sort of compromising for the HR director to conduct an investigation because there are concerns about whether certain processes were followed, and that's sort of on the HR director, then it might be appropriate to have outside counsel come in and do an investigation on behalf of the company to understand what has happened. Because if, as the HR person, you can't go off and really properly investigate an allegation that you didn't follow a certain process. Whistleblower activity is another area where you certainly want to reach out to an attorney to talk through, okay, what's the situation? What is the whistleblowing about is one issue that needs to be considered. And then dealing with the whistleblower themselves and ensuring that there's no retaliation is a separate issue. And those can get pretty complicated depending on the nature of the allegations and just all the facts and circumstances. So these are places to bring in a lawyer to talk through. But when you bring in a lawyer, you know, in some cases, you may want them to actually conduct the investigation. So you may go off and conduct the investigation yourself as the HR professional and sort of touch base with the lawyer about it, understanding that those conversations between you and the lawyer are going to be privileged, but the conversations between you and the folks that you're interviewing or investigating are not going to be privileged, right? Because there's no lawyer there. However, when you bring an attorney in, you may be able to have a privileged investigation. This gets really, really complicated. And so what you need to do if you're going to bring a lawyer in to do the investigation, which has a lot of advantages, is to consider the privilege concerns right at the beginning. That's the most important thing, is to have a really clear understanding of why are we doing this investigation and what is it going to be used for, so that we can have a good dialogue about whether there's going to be privilege over the investigation or the extent of the privilege risk, and also whether, you know, we may want to make the investigation public and the client may want to waive the privilege. These are things that it's really helpful to know up front. And so if you call your lawyer about some of these issues, discrimination, harassment, whistleblowing, and the lawyer is saying, you know, I think you may consider using an attorney to do this investigation, and here are what may sound to you like a bunch of hoops we need to jump through. It may be that they want to get a separate attorney to protect the privilege further. It may be that they want to get a separate engagement. It may be that they just want to talk through the purposes of the investigation. All of that is good due diligence to do up front. It's not meant to make your life more difficult. It's meant to really put some guardrails around the investigation to ensure that we're complying with our duty to protect confidences.
Elizabeth, can you talk really briefly about the whistleblower activity that might warrant an investigation and where we see that on the employment side? I think it's broader than you see like on TV.
Yeah, I mean, so use of funds is certainly a big issue. You know, somebody comes forward and says, I see that so-and-so is committing fraud, or I'm concerned about how this money is being used, or whether certain regulations are being followed. And that is is something obviously you need to look into, right? Because you don't want your company to be violating any laws, but also there are potential False Claims Act claims that the whistleblower could bring. So that's one area. I mean, another area might be sort of in line with the discrimination and harassment issues. I have big concerns about the environment that's being created in my workplace by certain individuals or a certain individual. They might not be the quote unquote victim of the harassment, but they're seeing something going on that they feel like needs to be looked into. And whenever somebody comes forward and sort of puts themselves out there to say, hey, I think my employer, the company, is doing something wrong, we need to proceed very carefully to ensure that we create an environment where people feel like they can do that. Because if you don't have people who feel like they can, raise their hand and point out when things are going wrong, more bad things will happen. And so there's sort of complications around dealing with the person who has blown the whistle and then also investigating the allegations at the same time. Some advantages to having a lawyer come in are that they can be sort of neutral. I really like getting called in to do an investigation for a client that isn't necessarily someone that I regularly advise, because in that case, I can come in and just provide them with a fresh perspective of what I see. It's sort of like having, just an audit almost come in and say, look, here's what's going on in this environment. And, here's some advice related to it. An attorney can also, if you get somebody who practices in the particular area where the allegations are particularly concerning, that person is going to know exactly where the risks are associated with the allegations. So discrimination, harassment, you're going to want an employment attorney, but there may be other situations where you've got whistleblowing on potential tax issues, and somebody can come in and help you see what's going on just with that outside perspective. Plus, an outside attorney doesn't have to work with everybody the next day, and so can kind of provide that neutral perspective. So I'm going to talk about a few cases just so you kind of have some background when we use certain words, that we're talking about certain cases. And one of those cases is Upjohn. So Upjohn's a Supreme Court decision from 1981, in which there's a company where the GC went and did an investigation because he had received concerns about certain funds. An example I just gave, these were payments outside of the country and how that was working. And the SEC got involved, the IRS sent a subpoena, and the company claimed the privilege. So what the lawyer had done was, send out a questionnaire to employees, interview some employees, and then when the IRS came, the company wanted to say, hey, this information is privileged because our general counsel went off and did this in order to tell us how to handle this situation. And the Supreme Court said, yeah, that's how representing a company works. The lawyer can talk with people within the organization to gather information. Those facts themselves are not privileged, but the communication between the employees of the organization and the lawyer are. But important distinction here, just so everybody is clear, the lawyer only represents the company, not individuals. And so it's the company's privilege that's being protected. And if the company decides, it needs to waive that privilege in order to, for example, litigate against a bad actor employee, then the company can do that. The employees themselves aren't represented by the general counsel in this situation. So if you go to the next slide, what we do every time we talk with employees is provide an Upjohn warning. We call it Upjohn because of this sort of monumental case. But really the point of this warning is to tell people, look, this conversation is protected by the attorney-client privilege, but my client is not you personally. My client is the company. My client is your employer. And we are also required to say, you know, your interests may differ from those of the company. In some cases, that will lead employees to say, you know what, I don't want to talk to you, I want my own lawyer. And that is another complication that you'll have to talk with your lawyer about in terms of how to handle those situations. But you should be aware that if you bring an attorney in, they're going to tell people this upjohn warning, and that may cause some employees some angst. I think, you know, at the end of the day, it's important for everybody to understand their rights. So these warnings are really important. So the couple other cases we just wanted to kind of bring to your attention. There's the fair Ellerth defense in employment discrimination or hostile work environment claims. And we may talk about this defense a lot. So we thought it might be helpful to kind of go through these cases just so you understand what we're talking about. So Fair versus the city of Boca Raton is a 1998 case in which a female lifeguard alleged that she was sexually harassed by her supervisors. And the big question in that case was, well, is the employer liable for the acts of supervisors, even if they didn't really know what was going on? And the court held that yes, you are liable for the acts of your supervisors. You can raise an affirmative defense to those allegations if you're able to show that you had a policy where people could come forward and bring complaints and that you responded promptly and appropriately. You've got to take steps to prevent the harassment and address it. So the idea is, yes, you're liable, right? Even if you didn't know about it, but you have a defense here. I think that some employers would like to be able to say, well, I didn't know about it. The less I know about what my supervisors are doing, the better. And that is the exact wrong approach. What the court is saying here is, you know, you need to take responsibility for the environment that you're creating. But if you do that, then you have an affirmative defense. And then we have the Ellerth case, which came out at the exact same time, very similar facts. So these cases are always talked about together. Same thing, female employee alleged that the VP of sales sexually harassed her. The important thing here to understand is sort of same concept, right? You can raise an affirmative defense to a hostile work environment claim perpetrated by a supervisor if you have a policy that allows people to come forward. The people have come forward. If they did, you responded appropriately. But importantly, your policy cannot require that the victim of the harassment go to their supervisor if the supervisor is the harasser. So if you've got a policy that says you have to go to your supervisor before the HR will do anything else, you've got a problem. This might be old hat to a lot of you, but the reason we bring this up is because if you want a lawyer to do an internal investigation, because you want to demonstrate that you have responded to allegations of a hostile work environment, then you need to consider these cases up front. If this is going to be your defense, then you're going to want this investigation to not be privileged. Like ultimately, you may decide we're going to waive the privilege so that we can demonstrate to the court and everybody else that when we received these allegations, we took it so seriously that we got lawyers involved who did this thorough investigation and had these findings. So these cases are really important as you talk to your lawyer about setting up an internal investigation, whether you want to waive the privilege, and how the privilege is going to work during the course of the investigation. So if you go to attorneys as investigators. So it's just a couple more things to consider when you have an attorney come in and do an investigation. Whether the attorney is performing an HR function. So we've talked a little bit about whether the matter is going to be privileged at the end of the day, whether the investigation results are going to be privileged at the end of the day. But another thing to consider is whether the attorney is coming in and really stepping into the HR function. There is an important case in North Carolina. It is in the business court. It's called Buckley. For those who are in-house counsel on the call, you may be familiar with it. If you're not, I commend it to you just to kind of go into some of the complications that arise when an outside attorney steps into the role of the HR professional. And so that's another thing that you need to talk to your lawyer about when you're setting up these investigations. There's some other pieces too. So whether you're doing the investigation yourself as an HR professional or you're having someone from outside do it, the integrity of the investigation is really what's going to drive whether you get good results and whether you can use that investigation as a defense. And so one of the things that we talk a lot about with our clients when we're setting these up is what are the walls around this investigation to ensure that there aren't influences coming in from, say, for example, someone's supervisor coming in and trying to push the investigation in a certain direction. And so another piece of that may be that we advise to have an attorney conduct the investigation and a different lawyer provide legal advice and create walls so that there really isn't communication between those two folks, and the person doing the investigation can provide a legal analysis with respect to what the risks are in light of the facts, and then close out, right? And a different attorney can continue to advise the client as a matter of ongoing concern. So these are just some things that your lawyer may want to talk to you about if you set up an internal investigation. All of them relate to our obligation to protect the privilege and our desire to ensure that you know when you're going to waive the privilege, if that's what you want to do, so that you don't inadvertently get yourself into a situation where communications have to be shared in litigation that you did not want to share in litigation. Okay, so now Jessi and I are going to talk through some scenarios in the hopes of putting some of this legalese and all this sort of rambling into something useful for you all. So Jessi, the first one, the company vice president asks for legal advice. Company vice president is in the car with his spouse. He's got you, Jessi, on speakerphone. So maybe just respond to that issue in and of itself.
Yeah, and I think, to be fair, we're all guilty of this temptation, right? And especially as more of us are working remotely and we're on the road, or we're doing something with our families when there's an important call that needs to be made. If you have a situation like this where you're talking on your Bluetooth or on speakerphone and a member of your family or a friend is present in that room, there's that unnecessary third party angle that we've talked about, and you're placing the privilege in jeopardy. And so you may be on the phone with us sometimes and we'll ask if anyone else is in the room, but it's always a good check for you before you place that call to think about who is in earshot and is this a conversation that you need to be able to assert privilege over down the road. And odds are pretty good if it's a reason you're calling us, you at least want the opportunity to assert that privilege.
Okay, but so what if though, going to the next bullet here, the company is based in Italy, it's got sort of this Italy, United States footprint. And in order to really get the legal advice, the company has asked their summer intern who speaks both English and Italian to come in and translate.
Yeah, so that is an example that's a closer call. And if you're probably tired of your attorney telling you that it depends, but this is truly a situation where these facts come closer to falling within the privilege because you have an argument that that intern is there to ensure that the legal advice is provided. It can get murky. And if you have someone on the other side who's really pushing, maybe it's like, well, how bad was your English really? And what did you talk about? And how is it possible that you could have a business arm in the US and not have a senior member of management who could have handled that phone call? But these facts come a lot closer to being a defensible assertion of privilege because there's a chance that without that intern, the legal advice could not be provided.
And I think too, Jessi, part of that goes to, is this intern an employee, you know, and have you properly set up an employment relationship here? I mean, one way that all these issues kind of interact with some of the other employment law issues are around, you know, if you've got somebody who is an independent contractor, or maybe they're misclassified and you start treating them like an employee, which one is it? You kind of have to pick, because if they're just an independent contractor, you may have some privilege issues there, just depending on how that relationship is set up.
There's another business court opinion, actually also out of Charlotte, that is N2 Biomedical, and it addresses the inclusion of a patent consultant in some communications with the patent attorney. And it really depends. You really have to be able to make a strong showing with someone like a consultant that the conversation could not have been successful unless they were part of that conversation. And the same applies, by the way, to if you have an HR consultant involved in the communication. They may be very helpful and they may be integral to your business operations. There is a risk to the privilege if they are included in conversations with the attorney, unless you all have talked it through ahead of time and come up with a basis to assert that privilege. Okay, Elizabeth, here's one for you. What if a mid-level manager emails the HR director and they have a question about a performance issue? The HR director responds to the mid-level manager with the HR director's assessment and copies the attorney on the response. But there's no point in that exchange where the manager or the HR director asks the attorney for their legal input.
Yeah, so this is the situation where we just get copied in and people have a misunderstanding that because they've copied a lawyer, now it's privileged. This would be concerning to me in that nobody contacted me to ask for legal advice. And so they're sort of just copying me in. If the way this would get closer is if there were communication in that email specifically asking for legal advice. So, you know, if instead the HR manager had forwarded the mid-level manager's question to me, right, then that would be an ask for advice, then that would be privileged. But just copying the attorney is not really going to be enough to assert the privilege. So people need to be aware of that, because I think that's a common misconception that they just copy and then might be surprised later to learn that that was not privileged.
And, you know, in the spirit of forwarding emails, I'll also just say it's always a good idea to check the email thread before you forward it, because there have been instances where maybe an attorney responded on day 3 of an email thread that's now 15 days old. And if you forward that email thread, even though you didn't realize it was at the bottom, you've waived that privilege if you're acting on behalf of the company. So just another thing to be aware of. Okay, Elizabeth, what if the company's senior officers hold a strategic meeting to talk about how they're going to maximize profits next quarter? And in that group of senior officers is the company's general counsel, and they're there as part of that brainstorming session.
Well, so this one too might be a misconception, because just because the lawyer's there, if we're not talking to the lawyer about legal advice, or relying on their legal expertise, then that's not really protected by the privilege. But I will say that you can have strategic meetings where legal advice is part of the strategy. You know, the legal risks are part of the analysis, as are the, financial risks, as are the PR risks, right? They're all kind of tied in together. And so that would kind of make this conversation closer to the privilege. But if you're just having the GC sit in on what is truly just a conversation about maximizing profits and has nothing to do with the legal risks, then you're going to have a harder time asserting the privilege. All right, Jessi, your turn. Okay. So the company president asks you to weigh in on a discrimination claim. But then the president takes your, I'm sure, very well written response, Jessi, and forwards it to the complaining person's immediate supervisor. What do you think?
Yeah, this is, I think, an interesting question here, because, we've cautioned you repeatedly now in this presentation against forwarding emails to someone who does not need to know that advice. There is potentially a reason here that the supervisor of the employee raising discrimination issues would need to know what my advice is. But a safer way to approach this would be to take the contents of what I've said and provide it to that supervisor in some other way. Just so there's not a direct link between, my Brooks Pierce email address and that immediate supervisor. And there are situations where you may not want the immediate supervisor to know what I'm saying either, right? If the employee is complaining that the supervisor is engaging in discriminatory behavior, there are probably good reasons not to share my communication.
Yeah, that's an excellent point. Well, so Jessi, what if in response to this discrimination claim, the company has the HR director conduct an internal investigation, and the HR director ascertains that supervisors have been engaging in discriminatory behavior?
Yeah, and this is the opposite of what we've been talking about, right? Because if the HR director, who is not a lawyer, conducts the investigation, then there's no privilege to start with. So you have a ready-made piece of proof, quote unquote, that the investigation took place. May or may not have been done in tandem with the attorney's advice, but there's never going to be privilege that applies to those results. And so if what you have is an HR director making notes saying, oh my gosh, this company is so discriminatory in every facet, and I interviewed 10 people and all 10 of them said that they were being discriminated against, and it's rampant, that piece of paper now is discoverable. So again, just something to keep in mind as you're thinking through strategy if you're responding to something like a internal complaint.
Yeah, and in terms of the fair Ellis defense, that's great that you responded so quickly and did the investigation, but you better be prepared to take action.
Mm-hmm.
Because if what you found was that the supervisor engaged in discriminatory conduct and you didn't do anything about it, well, you've just lost the lawsuit, because you've created a whole record of what the discriminatory conduct was, and now you have no evidence that you actually did anything about it.
Yep. Very good point. Be prepared to involve us with the findings, even if you're not prepared to involve us for the investigation. We would ask that you do both. At least make a phone
I
call.
know. I would call me now or call me later. I think calling me now is going to be a lot less painful, but
Yeah, absolutely. And Elizabeth, I see we have about 5 minutes left. I want to make sure if you all have questions, please feel free to drop them in the chat box. And we'll just otherwise keep going with these allegations for another couple of minutes.
yeah. So I guess the last example, I mean, we've talked a lot about this already, but is, same situation where the company receives these allegations, but instead of having the HR director do an internal investigation, they have outside counsel do it. What happens then?
Then you want to talk to us about strategy ahead of time. So we decide what might happen with the investigation and precautions we should take accordingly. Really quickly, this last example is just the temptation that I know comes from wanting to blame us sometimes when we tell you to do something that is not going to be well received by somebody. And I get that, we are very used to being the bad cop. But if someone is frustrated with you for a policy or a decision and you say, well, that's what our attorney told us to do, you're passing the buck in that moment, but you've also waived the privilege. So again, just something to keep in mind.
Well, and I don't mind sometimes people say, well, first of all, it's totally up to you whether to waive the privilege.
Yeah.
Sometimes it's really not a big deal. It's up to you. It's not that big a deal. And if that's what you need to do in order to just have a functioning workplace, to blame the attorney. Okay. But you need to be aware that that's what you're doing. And so that is really not a good idea in several circumstances to say, oh, well, our lawyer made us do that. Well, why? Now, if this ever comes into litigation, all the things that led to why the attorney gave that advice are in jeopardy. Not saying that we wouldn't be able to assert the privilege, but there are risks there.
So Elizabeth, I want to spend 30 seconds going back to this very dramatic hypothetical we started the presentation with, and your take on things that the client could have done differently or better. So as a reminder, you have an employee who's announced they're going to set their pants on fire if they don't get a raise. You get a phone call from the company president on speakerphone. The receptionist is sitting in the office. The door is open, and you discuss two very sensitive matters: the FMLA leave request and prior reprimands for discussing wages. The attorney, in response, tells you that there are liability concerns. You should be prepared to pay up. And in the hypothetical we gave, at the end of the day, you're probably stuck turning over all of this information to the employee's attorney. What are things that the company could have done differently?
Sure. Well, first of all, make sure that you have fire extinguishers and you're following all OSHA requirements. Sorry, I just had to joke. Also, right, the door should have been closed, not on speakerphone. Make sure you know how thick your walls are before you start putting the lawyer on speakerphone. The receptionist is not a person who needs to know the legal advice that's being given. And so they do not need to be in this meeting, which means their presence jeopardizes the privilege. So all of those things. I also sort of had a flag in my head. This is not related to privilege, but with respect to the FMLA, if who has that information, because there are additional protections for that information that people should not have. And so, why the company president would know the ins and outs of FMLA, of a certain FMLA process, I'm not quite sure. The HR person, yes. So those are other reasons that these are really sensitive matters that need to be dealt with the seriousness and confidentiality that they deserve in order to, protect everybody's privacy and also protect the organization.
Okay, 1:29. We're gonna get you guys out of here on time. Elizabeth, do you want to do the takeaways?
Yeah, thank you all, first of all, for being here. This has been helpful, I hope. At the end of the day, just try to remember that what we're doing and why we did this presentation is in order to help you all protect information. I think I'm supposed to say that there's SHRM credit, but it will not be available until after the presentation concludes on the final slide.
And the last thing I'll add really quickly, we didn't talk very much about this, but the receptionist notes in that example, if you have things that you are like emails or notes or documents, when in doubt, if you've spoken with your attorney, label them. They're privileged, they're confidential, do not distribute this. Make it as hard as possible for that document or that email to inadvertently get shared with someone who is outside of that privilege bubble. I did not see any questions come in. If you do have questions after the fact, Elizabeth or I would be more than happy to talk you through whatever's on your mind. And we do really like helping clients troubleshoot matters as they arise.
Thank you for attending today's presentation. We will now end the webinar.